Okay. Hello, everyone. Welcome to another session of #MentorOurs by Lawyered. Today's topic is developmental trends in arbitration in India, and we're very pleased to have with us special guest Rashi Bansal, ma'am, advocate on record and founding partner RB Law. Ma'am, thank you for joining us today. Rashi Bansal, ma'am, graduated in 2009 and has been a practicing lawyer since then. Mainly working in the fields of litigation and litigation in the corporate and financial industry before the NCLT. And ma'am also works in matters relating to debts, commercial disputes, quasi-criminal matters in the High Court and Supreme Court. Apart from this, ma'am's other practice areas also include intellectual property rights, dispute resolution, international commercial contract disputes, etc. Thank you very much for joining us, ma'am. Today, again, before we begin, I'd just like to remind our audience to please keep yourselves on mute. And the attendance link will be passed around in the chat box for you to fill out. Please do fill that out so that we can get your certificates to you. And lastly, for all the questions that arise during the presentation, please wait till the end. We're going to have a separate segment for just answering your questions. Please send your questions to me in the chat box. Yeah, let's begin, ma'am. Thank you very much.
Thank you, Samir. Next slide, please. Samir, can I have the next slide?
Yeah.
Yeah, thank you. So, good evening, everyone. We will be talking about the developments in arbitration law today. But before that, I would like to tell you how arbitration law was introduced in India. So the significant increase in the role of international trade in the economic development of nations over the last few decades has been accompanied by a considerable increase in the number of commercial disputes as well. In India too, the rapid globalization of the economy and the resulting increase in competition has led to an increase in commercial disputes. In many parts of the world, rapid development has meant increased case loads for already overburdened courts, further leading to notoriously slow adjudication of commercial disputes. As a result, alternative dispute resolution mechanisms, including arbitration, have become more crucial for businesses operating in India as well as those doing businesses with Indian firms. Courts have also adopted a pre-arbitration approach, and a series of pro-arbitration rulings by the Supreme Court of India and High Courts have attempted to change the arbitration landscape completely in India. To address the rising concerns with the primary purpose to encourage the arbitration as a cost-effective and time-efficient mechanism for the settlement of commercial disputes in the national and international spheres, the 1996 Act, which repealed the 1940 Act, was enacted to provide an effective and expeditious dispute resolution framework. Next slide, please. The idea was to inspire confidence in the Indian dispute resolution system, attract foreign investments, and reassure international investors in the reliability of the Indian legal system to provide an expeditious dispute resolution mechanism. The 1996 Act has three significant parts. Part 1 provides for any arbitration conducted in India and enforcement of awards thereunder. Part 2 provides for enforcement of foreign awards. Any arbitration conducted in India or enforcement of award thereunder, whether domestic or international, is governed by Part 1, while enforcement of any foreign award to which the New York Convention or the Geneva Convention applies is governed by Part 2 of the 1996 Act. And Part 3 provides conciliation. In today's session, we will mainly be focusing on Part 1 and its developments. The 1996 Act contains two unusual features that differed from the Unicitral Model Law. Firstly, while the Unicitral Model Law was designed to apply only to international commercial arbitrations, the 1996 Act applies to both international and domestic arbitrations. Secondly, the 1996 Act goes beyond the Unicitral Model Law in the area of minimizing judicial intervention. The changes brought about by the 1996 Act was so drastic that the entire case law built over the previous 56 years on arbitration was rendered superfluous. The Supreme Court in 1999 in Sundaram Finance versus NEPC held that the provisions of this Act, which is the 1996 Act, have therefore to be interpreted and construed independently, and reference to the 1940 Act may lead to misconstruction. In the absence of case laws and a general understanding of the Act in the context of international commercial arbitration, several provisions of the 1996 Act were brought before the courts, which interpreted the provisions in the unusual manner. Arbitration in India is still evolving. One of the objectives of the 1996 Act was to achieve the twin goals of cheap and quick resolution of disputes. But current ground realities indicate that these goals are yet to be achieved. The ground realities can be ascertained from the study and analysis of the various aspects of conducting the arbitration. However, today we would be discussing the developments in arbitration law through three modes: Arbitration and Conciliation Amendment Act 2015, the judgments that shape the arbitration law in India, and the Arbitration and Conciliation Amendment Act 2019. Next slide, please. Thank you. So the modification introduced by the 2015 Amendment Act have made significant changes to the Act and are in the right direction to clarify several issues about the objectives of the Act. There were two main objectives behind the amendment of the Arbitration and Conciliation Act, which were to make arbitration more investor-friendly, cost-effective, and suitable for expeditious disposal of cases, to facilitate in making India a major center for international commercial arbitration. We are now going to discuss the major amendments that were introduced by the Arbitration and Conciliation Amendment Act 2015. So first was interim relief. It was divided into two parts, from court and from arbitral tribunal. So after the judgment of the Supreme Court in Bharat Aluminium versus Kesar Aluminium, which is known as BALCO, which we will be discussing later today, the Indian courts had no jurisdiction to intervene in arbitrations which were seated outside India. Post BALCO, if the assets of a party were located in India and there was a likelihood of the dissipation of the assets, the other party could not approach the Indian courts for interim orders. Since the interim orders made by arbitral tribunals outside India could not be enforced in India, it created major hurdles for parties who had chosen to arbitrate outside India. This anomaly has been addressed in the Amendment Act with the insertion of Section 2, Subclause 2, which makes the provision for interim reliefs also applicable in cases where the place of arbitration is outside India, subject to an agreement to the contrary. The Amendment Act provides that in case the court passes an interim order, arbitration proceedings must commence within 90 days from the date of such order or within such time as prescribed by the court. This amendment was brought in to ensure that that no party misuse the provision, but strategically obtaining ex parte or ad interim orders and not proceeding for the arbitration. However, there is no clarity on whether the 90-day period would commence from the date of the ex parte or ad interim order or the final order in the proceedings under Section 9. This aspect should have been clarified. The better approach perhaps would have been to specify that 90-day period commences from the date of filing of the petition to drive the parties to the arbitration. Now we comes to arbitral tribunal. The amendments to Section 17 empower the arbitral tribunal with the same powers as that of a court under Section 9. To facilitate the parties to approach the arbitral tribunal and reduce the intervention of courts, the Amendment Act provides that once the arbitral tribunal has been constituted, courts cannot entertain an application for interim measures unless there are circumstances which may not render the remedy of obtaining interim orders from the arbitral tribunal efficacious. The Amendment Act also clarifies that such interim measures granted by the arbitral tribunal would have the same effect as that of a civil court under the Civil Procedure Code. This is a significant development, as the interim orders of the arbitral tribunal under the earlier arbitration regime could not be statutorily enforced, virtually rendering them meaningless. However, in a recent judgment passed by the Kerala High Court, the single judge has taken a view that under the Amendment Act, the Arbitral Tribunal cannot pass an order to enforce its orders, and the parties will have to approach the courts for seeking such enforcement, thereby making the enforcement of arbitral awards cumbersome. It will be interesting to see how the other courts interpret this judgment and if this stands the test of further judicial scrutiny. Under the new regime, the Arbitral Tribunal has the power to order interim measures even after the making of the arbitral award, but before it is enforced. However, this is inconsistent with Section 32, which provides that the mandate of an arbitral tribunal shall be terminated after the making of the final award. If the arbitral tribunal ceases to have jurisdiction after passing the final award, it is inconceivable as to how it would have the power to order interim measures after making the final award. This anomaly had to have been rectified by appropriate amendments in Section 32. The next is limited scope to refuse arbitration request. The amended Section 8 empowers the judicial authority to refer the parties to arbitration when there is an arbitration agreement, unless it finds prima facie that no valid arbitration agreement exists. While the scope under amended Section 11 is limited to the examination of the existence of an arbitration agreement, scope under amended Section 8 appears to be broader, inasmuch as the judicial authority can also examine the validity of the arbitration clause. This appears to be different standards set for examination of an arbitration agreement under Section 8 and 11, which ought to have been avoided. Next is amendments to grounds for challenging arbitration award. The scope of public policy in Section 34 has been narrowed, and the award can be set aside only if the arbitral award was induced or affected by fraud or corruption, is in contravention with the fundamental policy of India, conflicts with the most basic notions of morality or justice. In terms of this amended provision, an award cannot be set aside merely on the ground of erroneous application of the law or by reappreciation of evidence. Now, is there an automatic stay of arbitral award? There used to be. Before the Amendment Act, the mere filing of a challenged petition to the arbitral award would result in an automatic stay of the arbitral award. The court would take several years to decide the petition, making the process of arbitration time-consuming and ineffective. In a welcome move, the Amendment Act provides that there would be no automatic stay of the arbitral award, and a separate application will have to be filed seeking stay of the arbitral award. The court is now required to record reasons for the grant of stay, and the provisions of the Civil Procedure Code for grant of stay of a money decree have been made applicable, meaning thereby that the losing party will necessarily be required to either deposit some part or the entire sum awarded in the arbitral award or furnish security as the court deems fit. We will be discussing the interpretation of this provision in the latter part of the webinar. Now, we come to time-bound proceedings. The Amendment Act provides for faster timelines to make the arbitration process more effective. The proviso to Section 24 has been added, providing for the Arbitral Tribunal to hold oral hearings for evidence and oral argument on a day-to-day basis and not grant any adjournments unless sufficient cause is made out. The Arbitral Tribunal has now been vested with the power to impose heavy costs for adjournments without sufficient cause. Every arbitral award must be made within 12 months from the date the arbitrator received a written notice of arbitration. The parties may mutually decide to extend the time limit by not more than 6 months. If the award is not made within 18 months, the mandate of the arbitrator will terminate unless the court extends the period upon an application filed by any of the parties. Further, while extending the time for making the award, if the court finds that the delay was attributable to the arbitral tribunal, it may order reduction in the arbitrator's fee by not exceeding 5% for each month of such delay. The court, while extending the time limit, would also have the right to change the arbitrator as it may deem fit. An application to the court, as stated above, would be endeavored to be disposed by the court within 60 days from the date of opposite party receives the notice. A challenge to an arbitral award should be disposed expeditiously and in any event within 1 year from the date on which notice is served upon the party. Section 11 also is now leave to be decided within 60 days from the date of service. In an arbitration regime that was plagued with delays and cost, this is a good development. However, the parties would be forced to go court to court to seek extensions of time to complete the arbitrations, which is an undesirable situation. Further, the proposed timeline of 12 months to pass the arbitral award is very ambitious, even by international standards. There are some complex disputes, the resolution of which may not be possible within this time frame. Even the Law Commission in its report had recommended time for 24 months to complete the arbitration proceedings. Such ambitious timelines may act as a deterrent for foreign parties to choose India as the street of arbitration in complex issues. Now we come to fast track procedure. So section 29B has been introduced, which gives an option to the parties to agree on a fast track mechanism under which the award will have to be made within 6 months from the date the arbitrators receive the notice of appointment. The dispute would be decided based on written pleadings, documents, and submissions filed by the parties. Oral hearing can be held only if all the parties request or the arbitral tribunal considers it necessary for clarifying certain issues. There may not be too many occasions where the parties to an ongoing dispute agree on anything, let alone agree on a fast track procedure. A new cost regime procedure has also been introduced in the Amendment Act. Section 31A has been introduced, which gives wide powers to the arbitral tribunal to award cost. The arbitral tribunal can decide whether the costs are payable, the amount of cost to be needed when they need to be paid. The provision further provides that generally the unsuccessful party will be ordered to pay the cost to the successful party. The cost may include fees and expenses of the arbitrator, courts and witnesses, legal fee and expensive administrative cost, or any other cost that has been incurred in relation to the arbitral proceedings. The conduct of parties is a determining factor in awarding the cost, including the refusal of a party to unreasonably refuse a reasonable offer of settlement made by the other party. The 5th and 7th schedule has been inserted, which provides a guide in determining circumstances for ineligibility of the arbitrator. There is now a cap on fees to arbitrator. The 4th schedule has been introduced, which provides the model fees in case of arbitrations other than the international commercial arbitrations, and in cases where parties have agreed to the rules of an arbitral tribunal, with a view to ensure that the arbitration proceeding does not become very expensive. Section 11A(2) has been introduced, which details the procedure for central government to amend the 4th schedule. However, since the High Court of each state is required to frame rules after taking into consideration the rates mentioned in the 4th schedule, this may lead to a disharmonized fee regime across the country. Next slide, please. Now we come to the...
Ma'am, can you repeat your previous point, please? Sorry to interrupt.
I'm sorry, which one?
Ma'am, the last point that you said.
The cap on fees to arbitrator?
Yes, ma'am.
Okay. So the 4th schedule has been introduced, which provides the model fee in case of arbitrations other than international commercial arbitrations, and in cases where parties have agreed to the rules of an arbitral institution, with the view to ensure that the arbitration process does not become very expensive. Section 11A(2) has been inserted, which details the procedure for central government to amend the 4th schedule. However, since the High Court of each state is required to frame rules after taking into consideration the rates mentioned in the 4th schedule, this may lead to a disharmonized fee regime across the country. Now we are going to discuss the important cases that have shaped the arbitration in India. Although there are plethora of cases that have been decided by the Honorable Supreme Court and various high courts, we are restricting today's webinar to these judgments that have been mentioned on the PowerPoint presentation. So firstly, we will discuss Bhatia International versus bulk trading. So this judgment was passed in 2002, and in Bhatia International, the Supreme Court ruled that the Arbitration and Conciliation Act 1996 applies to international commercial arbitrations held outside India as well. Now, what are the facts of this case? So there was a contract contained an arbitration clause which provided that the arbitration was to be as per the rules of the International Chamber of Commerce. The issue that arose before the courts were whether Indian courts have power to grant interim relief under Section 9 of the Arbitration and Conciliation Act. A three-judge bench of the Supreme Court considered the matter of a request to an Indian court for interim measures of protection by a party to an arbitration seated in Paris. One of the respondents had sought interim relief from the court under Part 1 of the Act. The appellant objected that the application could not be allowed on the basis that Part 1 did not apply to arbitrations seated outside India. The district judge held that the application was maintainable. The matter eventually reached the Supreme Court. The court held that the provisions of Part 1 of the Act apply to all arbitrations, including international commercial arbitrations seated outside India, unless the parties have expressly or impliedly excluded its application. The ratio in Bhatia was subsequently extended in other decisions to permit Indian courts to set aside foreign awards, as it was done in Venture Global Judgment, and to appoint arbitrators in arbitrations seated outside India. Bhatia and the string of cases that follow it were widely criticized for judicial overreach and for creating significant uncertainty and delay in arbitrations that are seated outside India but involve Indian counterparties or laws. It has thus become standard practice in India-related commercial transactions and arbitration agreements to expressly exclude the application of Part 1 to arbitrations seated outside India with the view to escape the consequences of Bhatia. However, in 2012, the Constitutional Bench, 5 judges bench of the Supreme Court overturned the Bhatia judgment and on 6 September 2012 delivered its much awaited decision in Bharat Aluminium versus Kesar Aluminium, which is popularly known as the Balco judgment. After laudable consideration of jurisprudence laid down by various Indian and foreign judgments and writings of renowned international commercial arbitration authors, the Supreme Court ruled that findings of judgment in Bhatia International and Venture Global were incorrect. It concluded that Part 1 of the arbitrations which were seated outside India, irrespective of the fact whether parties chose to apply the act or not, is not applicable. Hence, getting Indian law in line with the well-settled principle recognized internationally that the seat of arbitration is intended to be its center of gravity. The Supreme Court concluded that the Act has adopted the territorial principle unequivocally accepted by the unilateral model law, thereby limiting the applicability of Part 1 to arbitrations which take place in India. It further stated that the territoriality principle of the Act precludes Part 1 from applying to a foreign seated arbitration, even if the agreement purports to provide the arbitration proceedings that will be governed by the Act. So that's how the Bhatia International Judgment was overturned by the Supreme Court in Bharat Aluminium. Now in 2014, the Supreme Court in Enacon judgment has tendered a landmark decision, affirming the pro-arbitration outlook towards the Indian courts that have been developed over the past few years. The judgment is a step in the right direction to bring Indian arbitration law in line with international jurisprudence and to aid India being perceived as an arbitration-friendly jurisdiction. The Supreme Court started out by stating that the legislative mandate under Section 45 of the Indian Arbitration Act only allowed the court to decline referring a dispute to arbitration if the agreement was found to be null and void, inoperative, or incapable of being performed. A party is required to contend and prove that one of these infirmities exists, and the mere allegation that the underlying contract containing the arbitration clause was not properly concluded and would not be enough to fall within the parameters set out in Section 45 of the Indian Arbitration Act. The Supreme Court held that the signing of the agreement by the parties together with evidence of past dealing, all of which was subject to arbitration, was enough for the court to arrive at a prima facie conclusion that the parties intend to arbitrate and on that basis refer the matter to arbitration. The Supreme Court supported its above conclusion by asserting that parties cannot be permitted to avoid arbitration without satisfying the court that it would be just and in the interest of all the parties not to proceed with arbitration. The court also considered the widely worded arbitration clauses where all disputes, including those with regard to the validity of the agreement, were to be referred to arbitration. The court reiterated the concept of separability of the arbitration agreement and held that an arbitral tribunal had jurisdiction to consider claims even when there is a dispute as to the validity of the underlying contract. The Supreme Court went on to hold that in the present case, the issue as to whether the agreement was properly concluded would be one of the questions that the arbitral tribunal needs to decide. The Supreme Court also held that although there were some errors in the drafting of the clause, such as the clause's failure to specify the procedure for appointment of a third arbitrator, the clause was not unworkable or pathological. The Supreme Court held that courts are required to adopt a pragmatic approach and not a pedantic or technical approach while interpreting or construing arbitration clauses, and must try to give effect to the intention of the parties to arbitrate where this is clear. Further, the Supreme Court relied on the established jurisprudence as mentioned in the Balco judgment by concluding that by choosing to apply the Act, the parties had made a choice that the seat of arbitration is India. The Supreme Court held that having chosen all three applicable laws to be Indian laws, the parties would not have intended to have created an exceptionally difficult situation of extreme complexities by fixing the seat of arbitration in London, and thus concluded that in the facts of the case, it would not be appropriate to read the word venue as seat as contended by the respondents. In the impugned order, the Bombay High Court concluded that though London was not the seat of arbitration, the English courts would have concurrent jurisdiction since venue of arbitration was London. The Supreme Court disagreed with this finding of the Bombay High Court and held that once the seat of arbitration was established, it was clear under both Indian and English law that the courts of the seat of arbitration would have exclusive jurisdiction to exercise supervisory powers under the arbitration. It was further held that allowing different courts from different jurisdictions concurrent jurisdiction over an arbitration would lead to unnecessary complications and inconvenience, which would in effect frustrate the purpose of arbitration, which is a speedy disposal. Based on this finding, the Supreme Court granted the anti-suit injunction against the respondents, restraining them from pursuing any relief from the English High Court. The next and very interesting judgment is Harmony Innovation judgment. In this case, the Supreme Court has clarified the scope of an arbitration agreement entered before the decision of Balco. The Supreme Court has held that pre-Balco arbitration agreements must be considered based on the principles laid down in the Bhatia International judgment. The Supreme Court had to consider that in a scenario where the agreement has been executed pre-Balco, the addendum has been executed post-Balco, the addendum amends only certain clauses of the agreement, not the arbitration clause contained in the agreement, whether the arbitration clause in the agreement should be interpreted in accordance with the principles laid down in Bhatia International or Balco. After determination of the above issue, another aspect which required determination by Supreme Court was whether the jurisdiction of the Indian courts would be ousted applying the principles of Bhatia International or Balco. The Supreme Court, after analyzing various decisions on applicability of the Act to arbitrations seated outside and relying on the presumed intention test, concluded that in the instant case, the parties intended to keep the judicial seat of arbitration as London on the basis of various phases included as mentioned in the arbitration clauses. The Supreme Court further went on to hold that the implied exclusion principle as stated in Bhatia International would be applicable. That is, the parties' intention to have London as the jurisdictional seat of arbitration, arbitrator being the members of the London Arbitration Association, and the contract being governed by English law, evidenced the parties' intention to exclude the applicability of Part 1 of the Act. Thus, the ultimate finding of the Supreme Court was that though the High Court erred in applying Balco to the facts of the instant case, it's concluded that the ADJ had no jurisdiction, which was correct. In 2016, the Supreme Court, after a long-drawn dispute, has firmly established that the two-tier arbitration clauses are valid and are not against the public policy in India. The arbitration agreement contained a two-tiered arbitration procedure, providing for a first instance institutional arbitration in accordance with the ICA rules to be held in India. In the event of disagreement between the parties in respect of the correctness of the first award, the arbitration agreement granted either party a right to appeal against the first award before an appellate tribunal to be constituted in accordance with the ICC rules to be held in London. The law of the main contract was Indian law. The Supreme Court affirmed that the intention of the parties to reserve a right to an appellate review of the first award is unambiguously clear from the wording of the two-tiered arbitration agreement. Notably, the Apex Court also observed that the 1996 Act neither explicitly nor implicitly bars parties to resort to appellate arbitration clauses. Secondly, the Supreme Court drew the distinction between legal and statutory right to appeal. In this case, the election of an arbitration appellate mechanism qualified as a legal right premised on an agreement between the parties. Thereafter, the Supreme Court held that unilateral model law and hence the 1996 Act allows parties to an arbitration agreement to reserve their right to appeal against that award. The second last judgment is Bcci versus Kochi Cricket. In this judgment, it is actually known as a landmark judgment because the Supreme Court clarified the applicability of the Arbitration and Consolation Amendment Act 2015, which we discussed earlier in this webinar, to pending and court proceedings commenced under the Arbitration and Conciliation Act. When the Arbitration Act was amended in 2015, one important amendment was Section 36, which relates to the enforcement of awards. It now provides that there is no automatic stay of enforcement whilst an application to set aside an award under Section 34 is pending, and the award will be enforceable unless a separate application to stay enforcement is made and granted by the court. The court has the discretion to impose conditions on the stay, including, for example, a requirement to deposit all or any part of the amount that the court may deem fit. The 2015 amendments to the Arbitration Act came into effect on 23rd October 2015. The issue in BCCI judgment was whether the new Section 36 also applied to challenges to awards under Section 34 filed before 23rd October 2015, that is the day on which the 2015 Amendment Act was implemented. Various high courts had reached conflicted decisions on this issue. The Supreme Court found that the new Section 36 would apply to challenges filed before 23rd October 2015 and which were pending at that date. It observed that execution was a procedural, not substantive matter, and so the 2015 amendment could apply to extent challenges. Interestingly, at the time of arguments in the BCCI case were ongoing, the government approved the text of Arbitration and Conciliation Bill 2018. Clause 87 of the bill provided that the 2015 Amendment Act shall apply only where the arbitration had commenced prior to the commencement date. With Clause 87, the automatic stay on enforcement of award upon a challenge being filed would apply for all awards arising out of an arbitration that commenced prior to October 23, 2015. Upon bill being brought to the notice of the Supreme Court in the BCCI judgment advised the government to not enact Clause 87. However, the government still went ahead and by Amendment Act 2019 inserted Section 87, which was later held unconstitutional in the Hindustan Construction Company judgment. So the last judgment, which is Hindustan Construction Company judgment, held Section 87 unconstitutional. Pertinently, Section 34 was amended to narrow down the scope of challenge to an arbitration award, and Section 36 was amended to do away with the automatic stay on an arbitral award, which came into play at the instance of the award debtor filing a challenge petition under Section 34, which we discussed earlier. In the light of the drastic implications of these amendments on ongoing arbitral proceedings and connected court proceedings, there arose a controversy with respect to the prospective or retrospective application of the 2015 Amendment Act. The Supreme Court in this judgment struck down the insertion of Section 87 to the Arbitration Conciliation Act, calling it manifestly arbitrary and in violation of Article 14 of the Constitution of India. The newly inserted Section 87 of the 1996 Act contemplated that there would be an automatic stay on arbitral awards the moment they are challenged under Section 34 of the 96 Act if they pertain to arbitral proceedings commenced before October 23rd, 2015. That is the date of enactment of the Arbitration and Conciliation Amendment Act 2015. This was irrespective of the fact that the state court proceedings under Section 34 of the 96 Act commenced prior to or after October 23rd, 2015. Section 34 application only had to relate to an arbitral proceeding commenced prior to October 23rd. The Supreme Court held that Section 87 would result in there being an automatic stay on all such arbitral awards arising out of arbitral proceedings commenced before the date when the 2015 amendment came into force, which would rather delay the process of enforcement of arbitral awards and increases the interference of courts in arbitration matters, in absolute contravention of the primary object and purpose of the 2015 Act. Now we come to the last leg of today's webinar, which is the Arbitration and Conciliation Amendment Act 2019. Next slide, please. Thank you. So the Arbitration and Conciliation and Amendment Act 2019 is in consonance with the Amendment Act 2015. However, it clarifies certain issues. So firstly, Section 161CA has been introduced to define an arbitral institution as an arbitral institution designated by the Supreme Court or a High Court under the Act. The Amendment Act also empowered the Supreme Court in the case of international commercial arbitration and the High Court in cases other than international commercial arbitration to designate arbitral institutions for the appointment of arbitrators. Such arbitral institutions will be graded by the Arbitration Council of India. Where a graded arbitral institution is not available, the Chief Justice of the concerned High Court may maintain a panel of arbitrators for discharging the functions and duties of an arbitral tribunal. In the absence of a procedure to appoint an arbitrator or failure of such procedure under the agreement, the appointment will be made by the arbitral institution designated by the Supreme Court or the High Court. The application for appointment of an arbitrator will be disposed of by the arbitral institution within 30 days from the date of service of notice to the opposite party. The arbitral institution will determine the fees of the arbitral tribunal and the manner of its payment of the arbitral tribunal subject to the rates specified in the 4th schedule of the Act. An arbitration council was also introduced by adding Part 1A, which will be established by a notification by the central government, and its headquarters will be in Delhi. The composition of the council will include a chairperson who is a judge of the Supreme Court, Chief Justice of a High Court, judge of a High Court, or an eminent person having special knowledge and experience in the conduct or administration of arbitration, who will be appointed by the central government in consultation with the Chief Justice of India. The other members of the council will include an eminent arbitration practitioner and an eminent academician. The ex officio members of the council will include the secretary to the Government of India in the Department of Legal Affairs, Ministry of Law, and Justice, and secretary to the Government of India in the Department of Expenditure. One representative of a recognized body of commerce and industry will be a part-time member. The council will promote and encourage arbitration, mediation, conciliation, or other alternative dispute resolution mechanisms, and for that purpose will frame policy and guidelines for the establishment, operation, and maintenance of the arbitration. There comes the grading of arbitral institutions and arbitrators. The council will make grading of arbitral institution based on criteria relating to infrastructure, quality, caliber, performance, and compliance of time limits for disposal of the international and national arbitration. There are certain timelines as well that has been decided under the Amendment Act. Firstly, the completion of pleadings. Section 23 has been amended to state that the statement of claim and defense must be completed within 6 months from the date the arbitrator or all the arbitrators received the notice for their appointment. In cases other than international commercial arbitration, the award needs to be made within 12 months from the date of completion of pleadings. In the case of international arbitrations, the award may be made as expeditiously as possible, and endeavor may be made to dispose of the matter within 12 months from the date of completion of pleadings. Where an application for extension of time is pending, the mandate of the arbitrator will continue till the disposal of the said application. There is an amendment to section 34, which replaces the word furnishes proof that with establishes based on the record of the arbitral tribunal, to clarify that the parties must rely on the record for arbitral tribunal alone at the time of challenge of the award. There is also an amendment to section 45, which mentions that unless it finds that the arbitration agreement is null and void, inoperative and incapable of being performed, this has been amended to substitute the words unless it finds. So all the amendments that I've mentioned in the Arbitration and Conciliation Act is mainly on the language that has been changed from in one form or the other. There are several qualifications and experience of arbitrators that have also been defined, which is a very lengthy details, which includes that the person should be a lawyer or a chartered accountant, a cost accountant, and that ways 9 criteria have been mentioned. The schedule also mentions the general norms applicable to arbitrators, including a lot, which means that the arbitrator should be impartial and neutral. He must be conversant with the constitution of law, the principles of natural justice, customs, customary law, etc. There also a specific amendment which mentions that the arbitrator, the arbitral institution, and the parties to the arbitration agreement must maintain the confidentiality of all arbitral proceedings, except the award where its disclosure is necessary for infringement, for implementation and enforcement of the award. The last is the applicability of Arbitration and Conciliation Act 2015. It was clarified that unless the parties otherwise agree, the amendments made to the Act by the Arbitration and Conciliation Amendment Act 2015 will not apply to arbitral proceedings which commenced before the commencement of the Amendment Act 2015, which is October 23rd, 2015. This overruled the position laid by the Supreme Court in Pcci. However, this provision, which is section 87, has been held unconstitutional by Supreme Court in Hindustan Construction Company Limited. Thank you. We can now open for the question answer round. So, Sameer, if there are any questions.
Yes, ma'am. Thank you. Thank you very much for your insights on this very vast topic. I feel that we covered a lot of very important points. There are a few questions that I'd like to bring forward. Just as a reminder for everyone who hasn't set their questions in, please do so in the chat box. Ma'am will be happy to answer them at this point. I think the first question obviously would, when it comes to arbitration and arbitrators as such, would be comparing them to the judges. What powers do they have in the conduct of proceedings?
Okay. So Sameer, all the arbitrators have equal powers as the judges have. So there is no discrimination as far as the powers are concerned. The arbitrator acts as a judge on the dispute. However, there are some limitations that all the orders that are passed under the Arbitration Act are not appealable. There is a specific provision that has been given for the contempt. So the arbitrator cannot issue contempt against the parties. The arbitrator needs to refer the contempt to the High Court, and only High Court can go ahead with the contempt. So these are certain limitations. Otherwise, the arbitrator has equal powers as of a judge.
And as obviously the comparison goes with judges and arbitrators, that judges, you have certain requirements to be appointed as judges, whether in the High Court or the Supreme Court. Are there any certain requirements as such for the arbitrators to be appointed? So
it depends on the agreement. If in the arbitration agreement any specific qualification is mentioned, for example, the arbitrator needs to be a judge, retired judge of a Supreme Court, or a civil engineer by qualification, then those criteria needs to be matched. If nothing like that is mentioned, then there is no criteria. Anybody whom the parties believe that is capable of deciding and resolving the dispute can be appointed as an arbitrator.
Ma'am, so what happens in instances when the parties cannot come to an agreement as to who is appointed as an arbitrator? Who takes it forward then, the appointment?
So in case of international arbitrations, Supreme Court, and in case of domestic arbitrations, High Court have powers under Section 11 to appoint an arbitrator. However, after 2019 amendment, there will now be an arbitral institutions which have been given power to appoint the arbitrators in case parties approach the Supreme Court or the High Court under Section 11.
Okay, thank you, ma'am. And furthermore, keeping in line with the arbitrators as such, what happens if the award that is granted by the arbitrator has been ignored by the individual it has been awarded against? Are there any sort of recourse available to the person who's been aggrieved again?
So the party, whosoever wants to execute its award, can file an execution petition in the court for execution of the arbitral award. So it can be done the way we do it in civil judgments that have been passed in favor of any party.
And in terms of appeal, are there any grounds on which or various orders that the arbitration can be appealed? Or is it only for specific instances?
Yeah, so for appeals, there are two very relevant provisions, which is Section 34 and Section 37. Section 37 provides certain orders against which an appeal can be filed. And Section 34 is a section under which the arbitral award can be challenged. Under the Amendments Act, these on the grounds on which these arbitration awards can be challenged have been minimized now. So the first and most important ground is public policy. And if the party can show that there is a breach of public policy in the award, the order will be challengeable before the respective court.
Okay, thank you, ma'am. Keeping in line with Section 34, as you mentioned, it was one of the ways that they could obviously appeal. But in terms of Section 34 specifically, under the Act, would this appeal operate as an automatic stay?
Not anymore.
Okay.
So that's what we discussed today, that initially there used to be a provision where there was an automatic stay. Then Amendment Act 2015 was introduced. Under the Amendment Act, there was an amendment which says that there will not be any automatic stay. However, it was prospective in nature, and if there was any case which was filed before 23rd October 2015, in those cases, there will be an automatic stay. So in BCCI judgment, the Supreme Court said that the Amendment Act will be applicable on the pending Section 34 as well. Then the government introduced Amendment Act 2019. In the Amendment Act 2019, the government introduced Section 87 to technically surpass the judgment that has been passed in BCCI. However, in the Supreme Court in 2019 passed another judgment and held Section 87 as unconstitutional. So there will be no automatic stay anymore.
Thank you, ma'am. For the basics of arbitration, I assume it's become the common practice that in most contracts that are drawn up, that you do have an arbitration clause. If there's any disagreement between the parties, that we will first refer to the matter to arbitration. My question at this point would be, would this process of going to taking up the arbitration process, would that be available to the parties if there is no such clause in the contract specifically?
No, there has to be an arbitration clause. In the absence of arbitration clause, the parties cannot go to arbitration. Then they have to seek remedies before the civil court.
Also keeping in mind the process of arbitration being the more popular choice because it is a lot faster than our main court, the entire court procedure. But a lot of people have come up to say arbitration is a lot more expensive compared to litigation. Could you give us your views on that, as well as how the payment in this in this issue is decided between the parties?
So I would not lie. It used to be an expensive procedure, but now with several amendments in 2015 and 2019, now a schedule has been issued under the Act, and the arbitrator cannot ask for more money other than what has been mentioned in the schedule. So although it is a little expensive in comparison to litigation, but then we are also seeking an early resolution. So there's a speedy disposal. So I believe that has a cost to it.
So even common people who are, say, above the, I mean, lower middle class or lower class in terms of earning capacity, would they be able to now refer matters to arbitration and
I believe they
perhaps
can.
get them? Yeah. Okay.
Yeah, I believe they can, because now there is a cap. Initially, there were circumstances where the arbitrators are quoting exorbitant amount of fees from both the parties, and it was becoming extremely difficult for parties to pursue arbitration. But as the government of India has been trying to make India a friendly, business oriented country, so now they have put a cap to it. So on the basis of whatever the amount of dispute is, the party can decide the fee.
We have a question coming in from Asha Rani at this point. She asks, can a relative of both parties be appointed as an arbitrator with the consent of the parties? And if so, the award passed, if so, and the award has been passed, but one of the parties set aside the award on the ground that the arbitrator is not impartial, what would happen to the award?
So if other than the civil order, the courts normally remand the case back to the lower court. So if you're in high court and the court wants the case to be adjudicated again, the courts normally remand it back. But in arbitration, that is not possible. So once the award is passed, then it cannot be remanded back to the arbitrator for fresh adjudication. So once it is being held invalid or illegal by the court on the basis of the arbitrator not impartial, then it is gone. The only remedy is filing an appeal against that order.
And finally, for all the students who are watching, I'd like to pose this question as a former law student myself. Usually the avenues are either litigation or corporate law, but with the popularity of arbitration coming up, what would you suggest would be certain avenues related to internships or subject matter or qualities that you would need to succeed as an arbitration lawyer?
So there is no okay, so there is nothing specific as quality that you need to be an arbitration lawyer. You just need to understand the Arbitration and Conciliation Act. There are a lot of judgments that have been passed by the various courts on the Arbitration and Conciliation Act, because our courts have, initially we had Arbitration Act 1940, and the Arbitration Act 1996 was completely different from 1940 Act. So therefore, whatever jurisprudence has been written for 1940 to 1996, that will not be applicable on 1996 Act. So from 1996 till date, whatever judgments have been passed, whatever law has been laid down by the government, if somebody is familiar with those judgments and law, they can practice arbitration. So there is no specific qualification that is required to practice arbitration law.
Okay. I think that brings us to the end of our webinar. I'd like to thank you, ma'am, very much for taking your time and the effort you put into this webinar. We really do appreciate it. Thank you from lawyer's side. And we'd like to thank our audience also for joining in and being a part of this webinar. Before everyone leaves, if you haven't already filled up the attendance sheet, please do so. We'd be happy to, it's already in the chat box for your use. So please do fill it up. Otherwise you won't be able to get your certificates in time. Once again, thank you very much, ma'am. This has been a very informative and very interesting series. We hope to see you soon again on #Mentors Are by Lawyer.
Thank you.
Thank you very much.
Thank you, lawyer.